All right, everyone. Thank you all for coming. My name is Amr Kode. I'm an associate professor here at the Faculty of Law. I'm also a member of our faculty's Distinguished Visitors Lecture Series. So, along with me, we have none of whom happen to be in the room, apparently, so I can say what I want. Actually, I shouldn't because the camera's rolling. Our professor, Michelle Gallant, who is also the chair of the committee, Professor Katie Salagi, and Professor Daniel Diamond. And as my colleagues decide where to sit,
I don't want to
oh, just cut ahead.
Slow, colleagues.
And the lecture series, the goal of it is, of course, to have speakers come in to speak on matters dealing directly with the law or very well connected to the law. And so with that in mind, we have a nice little schedule of speakers. We're not done with it yet, thankfully. We still have a couple more that were in the works. But our first speaker for this academic year is Dr. James Gacek, and I'm just going to go give a bit more of a bio here. So Dr. Gacek is an associate professor in the Department of Justice Studies at the University of Regina. He's a native of Winnipeg. He holds his PhD in criminology from Edinburgh Law School at the University of Edinburgh. His written publications focus particularly in three areas. They are one, corrections and community justice, which I think our talk today squarely fits within, green criminology, and three, the broader sociopolitics of judicial reasoning. So he's the author of Portable Prisons, Electronic Monitoring and the Creation of Carceral Territory, published by McGill Queen's Press in 2022. In addition to that sole-authored work, he's also deeply connected to our law school. He's with Dean Jockelson. They've together co-authored one book, they co-edited two other books, and I think contributed to them as well with chapters. Yes, is that right? Yeah. And he's currently one of the co-editors of the Manitoba Law Journal's annual criminal law issues. His talk today, as you can see from the screen, is entitled Rainbow Captives, the Conditions and Challenges for Queer Incarceration. Dr. Gacek's talk will be followed by a question and answer session. The talk will be recorded, but not the Q&A that follows. So feel free to ask open questions if you like. You won't be recorded at that stage. So without further delay, please join me in welcoming Dr. Gacek.
Good afternoon, everyone. Good afternoon. It's an absolute pleasure to be back here at University of Manitoba, and it's a wonderful experience to be here. So I'm very much looking forward to our chat today. So thank you kindly for the warm welcome and introduction. It's a pleasure to be here today speaking to you all on this very important and, I would argue, warranted topic. Let me first thank Robson Hall's Distinguished Visitors Lecture Series Committee for my invitation to be one of their distinguished visitors. I hope I'm distinguished enough to even be considered that, so I appreciate even just the title alone. And for inviting me to speak to you all today. Now, as a former Winnipegger myself, the city of Winnipeg holds a very special place in my heart, and as a former alum of the University of Manitoba, returning to this university to walk these hallowed halls is equally special to me. And of course, I'd like to thank everyone for coming to my talk today. My hope is that you find the lecture informative, intriguing, and maybe even thought-provoking. And I'm happy to chat further to those who would love to learn more about my research interests, or even just to chat about Winnipeg. I mean, I still love the idea of the old motto. I don't know why we changed it, one great city. It's always my favorite motto, so I very much love it. And we'd love to chat more about Winnipeg if you really want to. So, let us begin. Now, of course, I'm from the University of Regina, and so I want to also recognize the territory in which I work and live on, as well as being part of the University of Manitoba here and recognize the territory as well. So I respectfully acknowledge that I work and live on traditional territories of Indigenous peoples on Turtle Island. It is a place where the spirit of treaties signed between Indigenous peoples and settler colonial governments is not honored. Thus, I am committed to conversations and relationships in solidarity with Indigenous peoples for change, justice, and reconciliation in whatever form that might look like. I offer my gratitude to Indigenous peoples for their care for and teachings about our earth and our relations, and may we honor those teachings. So the title of my talk today is Rainbow Captives, the Conditions of and Challenges for Queer Incarceration. And given the focus of the lecture, perhaps a talk like this couldn't be more specific, or I should say, sorry, couldn't be more significant, especially with recent events locally, nationally, and internationally that speak to the challenges the queer community faces both within society and while in prison. I framed the focus of my lecture on my recent collaborative project with Dean Richard Jockelson, entitled Rainbow Captives Towards a Queer Carceral Studies, wherein Dean Jockelson and I are co-editors and in certain cases co-authors of certain chapters. And of course, we also work with wonderful research assistants to develop thoughtful and thorough chapters. And I must also take a moment to not only thank Dean Jockelson, who may grace us with his presence at some point during our talk. If he doesn't, I completely understand. But also for his support, guidance, thoughts, and kindness as he and I work through this research project. But we also graciously thank our RAs, Lauren, Marissa, and Ava. I believe Lauren and Marissa are here, which is wonderful. Sorry, scanning the crowd, trying to find everyone in the faces. Yes, and Ava, who is a research assistant of mine at the University of Regina. For their hard work and dedication to the project, thank you so much. And of course, we've culminated fascinating chapters from other contributors too, some from across Canada and others from around the world, including but not limited to the United States, the United Kingdom, Australia, and even Colombia. Too often, we see how shifts in society seemingly leach into spaces of incarceration, or as I'll refer to, carceral spaces, another area of research that I do conduct. Oh, there's Marissa. Sorry, I was wondering where you were. There we go, perfect. But never before have the incarcerated queer community and queer communities around the world faced challenges like it has now. And as you'll see, the collaborative research I'm undertaking with Richard and colleagues serves to promote reforms, systemic restructuring, and reconciliation with law, public policy, and justice systems around the world. Now, this lecture will draw upon two specific chapters Richard and I have worked upon with our RAs. The first focuses upon the socio-carceral dynamics of trans inmate case law, while the second explores the thematic analysis of Office of the Correctional Investigator, or OCI, reports. And in terms of the latter, and for those who are unaware, the OCI is the federal ombudsman that explores complaints about Correctional Services Canada, CSC, serving as a pseudo-watchdog to highlight the perennial problems CSC faces in housing their prison population. As we get started, I want to first provide a roadmap for where we're going to be going over the next 45 minutes or so. I'm also a social scientist, and as such, a good social scientist, if I can ever call myself one, operationalizes their terms. So I'll begin by asking, what do I mean by the term queer? What do I mean by the term carceral? And what benefit a queer carceral studies might provide us? I'll then share my thoughts on the research we undertook with each chapter, while also highlighting the trends we found in each research project. I'll conclude with a discussion of so what, namely, in other words, how we might be able to make better sense of the two chapters I'll be sharing with you today, and what implications this will have for queer communities going forward. So I also want to make it clear in our work and in our forthcoming, knock on wood, book, and in our promotion for queer carceral studies, that my usage of the term queer comes from a desire to be inclusive. Now, I recognize that there's no perfect umbrella term to encapsulate the 2S LGBTQ+ community, and no acronym that can contain all of its beautiful nuances. Rather than considering the term as something to be ashamed of, I align with those that use the term to reclaim the word as a positive label, while also recognizing its colloquial, contemporary use as an umbrella term for anything that is not cisgender and/or heterosexual. Of course, reclamation is messy. The word queer holds in its history both pain and empowerment. It has been a dagger and a hug, a dismissal and a welcome sign, a put down and a motivation to stand up. Even as Collins goes on to state, oops, my apologies, I'm too far. The word queer will always be pejorative in certain contexts, and it will always cause pain when used in a derogatory way, or an insistence that someone is abnormal and thus undeserving of fair treatment and love. But we should also acknowledge that the reclamation and reappropriation of the word is not a new phenomenon. Its reclamation dates back to at least the LGBTQ rights movement after the Stonewall riots in '69, after which people began to wear the word as a badge of honor, to say literally, we're here, we're queer, get used to it. To demand to no longer be left in the margins, to demand that we redefine what is normal and what is strange. Queer's original meaning and the reason it placed upon so many people like a scarlet letter. Queer is a word, then, I use with respect and love, but that said, it is equally important to respect how people choose to be identified. I also note here that in the context of some of the research I'm going to present today, I do switch between particular terms, and I do so with caution, respect, and love. I may even, my apologies, especially when we see bathroom bills target the ability for trans people to use washroom facilities, and the recent educational policy changes in New Brunswick and Saskatchewan regarding sexual education and pronoun use. It is important that we are specific about who those actions harm. Trans people, intersex people, gender non-conforming people, and the list goes on. More than ever before, we have a deep well of words to use to understand and to explain who we are, to decide what pronouns to use, and to choose who we love sexually and or romantically. So these words matter, and they matter intensely. Now, what do I mean by the word carceral? Well, before I explain, let me tell you about an almost universal truth. The prison captivates us. And why not? Prisoners, as the principal actors, are engaging, captivating characters. They've crossed the line of illicit behavior that we dare not, and they're now the protagonists in a unique world that most in society will only ever have rare glimpses of. Brick by brick, steel door by steel door, countless cavernous rooms cast in concrete, painted pathways demarcating who is in and who's out of bounds. Prisons, psychically and materially, breed feelings of exclusion and segregation. And when we think of life inside prison, especially from vivid images provided by popular media, it conjures up for us scenes of conflict, hardship, punishment, and moral drama. Not only do we witness this in popular media, but through claims makers actively promoting their own brand of change, or perhaps more cynically, from politicians who simply seek to advantage themselves in their quest to gain or retain power. Yet as captivating as prisons and prisoners remain to us, how these places and people remain bound up and come into contact with surveillance, punishment, and control is increasingly at rates and ways beyond historical standards. The extensive nature of spaces of incarceration, like I said before, carceral spaces, suggests a refreshed understanding of how these people remain captive within and beyond incarceration and within our current carceral age. As Vituli makes clear, despite the fact that queer and especially trans and gender non-conforming people are disproportionately incarcerated and otherwise affected by the prison system, queer studies has rarely examined the prison, and critical prison studies has rarely engaged with queerness. And so it's our hope through this work that we can start bridging those conversations together. Now, this begs the question, why do we need, and in our case, a book, on queer carceral studies? Well, conversations about sexuality and gender are becoming more commonplace in Canadian society. And equally important is how such conversations continue to be controversial, especially within prison systems and in carceral states around the world. It is clear there continues to be risk and security concerns of gender-based violence towards queer prisoners inside prisons and once released. As such, it's necessary to explore the challenges queer prisoners and formerly incarcerated persons face in the Canadian context, to offer more just and transformational paths forward. My interest in queer carceral studies and the interest of my co-authors and fellow contributors is also guided by two questions. Number one, what changes to society need to happen in order for safety and security for the queer community to materialize? And number two, how might we defend and or ally alongside queer communities to resist current or future carceral campaigns? So let's begin by focusing on the first set of research, co-authored with Richard, Lauren, and Marissa. Our intention was to explore significant and relevant case law to understand the impact it has upon inmates' bodies that do not conform to a strict gender binary. We also consider the construction of rights in the carceral system for these inmates. Trans people continue to have their bodies and lives scrutinized in various ways in society. Such scrutiny has even leached into spaces of incarceration, into carceral spaces. Our focus here queries the logic of genitocentrism, demonstrating how the law's reliance upon genitals as the primary signifier of gender contributes to the degradations and dehumanization of trans and other gender diverse individuals in prison. If there is a role for law to play in reflecting the diversity we see in trans inmates' identities and bodies, a thorough exploration of case law in corrections as it relates to trans inmates is required. So, the history of transgender healthcare in Canadian prisons begins in 1980, detailed by Laisha's testimony in Kavanaugh as a senior project manager for mental health at CSC at the time. In 1980, CSE undertook their first examination of how trans incarcerated people in federal corrections should be managed. The resulting recommendation, was that number one, hormone treatments should not be initiated during incarceration unless hormones had begun prior to incarceration, in which case they could be handled on a case-by-case basis, and surgery should only be undertaken near the end of someone's sentence. This recommendation formed the basis for the first trans inmate policy in '82, indicating that hormones could be continued if it appeared that the inmate would continue with sex reassignment after release, but made no mention of surgery during incarceration. Now, this frozen-in-time approach continued largely unchanged in CSE's health policy revisions in '87 and '97. The '97 policy, as you'll see up on the screens here, had general provisions for all essential medical care at CSE's expense and non-essential care at the inmate's expense, but it also made explicit mention on the treatment of gender dysphoria, as you can see. Kavanaugh held that Section 31's specialized prohibition on a particular surgery was unjustifiably discriminatory. However, Section 30 was justifiable insofar as it refused to house trans inmates in institutions aligned with their gender. The court ordered that trans people be reasonably accommodated by CSE, but did not order that it be made possible for trans women to be housed in women's prisons. This prohibition on gender-aligned housing persisted well into 2017. CSE's Commissioner's Directive 800-5, otherwise titled Gender Dysphoria, which took effect on January 9, 2017, specified that trans inmates must be held in genital-aligned institutions, meaning that relocation would only be considered for post-operative inmates. This policy was overwritten less than a year later by Interim Policy Bulletin 584, otherwise known as Bill C-16, which revoked the previous policy and imposed the following: a duty to accommodate based on gender identity or expression, regardless of the person's anatomy, in other words, sex, or the gender marker on identification documents, unless there are overriding health or safety concerns which cannot be resolved. Now, the 2017 shift is a result of C-16, which amended the Canadian Human Rights Act to include gender identity and expression as a protected ground of discrimination. Following this shift, over 70% of ensuing cases by trans inmates have either centered on or involved with transfer requests to a women's institution. This represents 5 out of the 7 cases between 2018 and 2021. The remaining 2 cases are Chambly and Wally, which are sentencing decisions focused on pretrial conditions. Now, in 2022, Commissioner Directive 100, otherwise titled Gender Diverse Offenders, came into effect. This allows for medical care in accordance with international standards, including the following: gender-affirming search procedures, clothing, names, and pronouns, and perhaps most crucially, placement in an institution aligned with the gender or preference. Placement is to be regardless of official markers on identification, barring overriding health or safety concerns. Now, in the event of concerns which cannot be resolved, the persons will be placed in a sex-aligned institution. Now, notably, much of this policy, while taking great strides to implement affirming treatment, defaults back to genital-centric positioning. For instance, Section 31 notes that if they are unable to complete an intake assessment for placement, the person will be housed for the immediate term in a sex-aligned institution, rather than defaulting to alignment with an official gender marker or another metric. Additionally, incarcerated people are only eligible to have the sex marker changed in the CSE system when they've completed gender-affirming surgery, in contrast to the general population who may apply to change their gender marker without such requirements. So this is just giving us a bit of a background in terms of the history and historical context of what we're referring to here. So to ground our understanding of how prison policy is manifested in the lives and experiences of trans people in Canadian prisons, we collected a sample of 11 cases. Now, to collect this sample, we first located potentially relevant case law by conducting a series of keyword searches across different databases. From this preliminary body, we narrowed our sample to include only cases which featured 1, a transgender person in custody, whether detention, pretrial, or sentenced incarceration. Number 2, detailing their personal experiences within a prison setting, where number 3, those experiences are alleged to be connected to or caused by their gender identity. Cases were excluded from the sample when the person's trans identity was not relevant to the substance of the case or decision, or where potential adverse institutional treatment was speculated upon but not personally experienced. Now, to frame and complement the Canadian perspective, we also collected a sample of 12 American cases detailing the treatment of trans people in American prisons to give us some context of what we see between the two jurisdictions. In contrast to the Canadian sample, the American counterpart is not intended to be comprehensive of the available jurisprudence. It's simply too exhaustive, and we don't have that time. For the research we're doing, we have to be a bit more specific. The American sample is intended to provide an overarching view of the state of trans people's treatment within American institutions, as well as to give shape and contrast to different legal history of trans people in custody. This sample was compiled using the same search terms, and the sample relied more heavily on case law collected from the cited cases of relevant and recent decisions. This allowed us to gain a strong understanding of the issues and key precedents in American prisons' treatment of trans people and their legal options for remedy. These histories and comparisons allow us to better understand the possible futures for trans people in custody. So, what did we find? Well, several trends emerge out of the 11 cases when we're talking about Canada. First, 9 cases are within provincial centres, almost all of which are remand centres. The provincial prison system holds approximately 60% of the country's prisoners at any given time, but accounts for over 80% of the trans inmate allegations. This may indicate that federal policies and procedures have been working sufficiently that complaints have not made it to court or tribunal proceeding. However, the 2 federal cases, Kavanaugh and Bulashanas, are from 2001 and 2018 respectively, and encompass a wide spectrum in the state of CSC policies, and therefore it is difficult to say how effective federal policymaking has been at preventing allegations by trans inmates from appearing in court. The overrepresentation of provincial centres may mean that provincial correctional policies are lagging behind on trans inmates, which would certainly make sense given an utter lack of gender diverse policy in some provinces' correctional services. For example, Alberta, Manitoba, very laggard. Very much hardly any concerns for this type of policy. However, around half of these cases were out of BC, which has had an affirming policy in place for gender diverse offenders since 2015. BC houses around 10% of all provincially incarcerated people, and 6% of all incarcerated people in Canada. So moving to trends in the experiences of trans inmates in these cases, the strongest constant was the use of segregation seen in around 9 out of 11 cases, or over 80%. Now, the only cases which did not allege segregation as a result of their gender identity were Dawson and Lovato. Barring these 2 outliers, the overuse of segregation appears omnipotent and dominant in trans inmate cases. And of the 11 cases in our sample, 6 allege experiencing harassment from inmates. This ranges from sexual or degrading comments to death threats and actual violence, but excludes sexual assault and sexual violence. Now, of the 5 remaining cases, 3 are pretrial cases alleging being kept segregated from other inmates, and we see this in McNabb, Chumbley, and Wally. Lovato has a narrow scope, makes no comment on conditions of confinement, and Dawson was detained for brief periods and makes no reference to being housed with other detainees. So these numbers, taken in conjunction with the judicial recognition of the vulnerability of trans inmates, indicate that high levels of harassment are common. Additionally, there are also lower reported rates of harassment from staff against trans inmates in around 4 out of 11 cases, and lower still reported rates of sexual violence, 3 out of 11 cases. Now, one possible explanation for the latter number is that the high rates of segregation successfully prevent sexual assault, insofar as every case reporting harassment from inmates also reports segregation. Alternatively, perhaps sexual assault is underreported by trans inmates left out of court proceedings, or perhaps is in fact less common than the other kinds of violence trans inmates face. This is something that is ongoing, and we have to have further research to examine this. Now, in terms of the 12 American cases, excuse me, one second. Thank you. In terms of the 12 American cases, they were located based on their use as precedents in other decisions, using the same criteria that we did for the Canadian cases. When comparing reports on American prisons to Canadian, 2 main points of interest emerge from our research. Number 1, the limited avenues American prisoners have to remedy issues surrounding their incarceration. And number 2, the nature of solitary confinement in American prisons. Now, for those of us who aren't familiar, American prison law relies disproportionately on the Eighth Amendment right to be free from cruel and unusual punishment as the primary or sole method of achieving justice for incarcerated people. Case law routinely dismisses 14th Amendment rights to due process under the law as being not often applicable to prisons. And only 2 cases in the sample relied primarily on a claim other than the Eighth Amendment. The most common allegation in American prisons is failure to provide adequate medical treatment, that's what we saw in 7 out of 12 cases, amounting to an Eighth Amendment violation. The primary issue with the use of the Eighth Amendment in these cases is its standard for finding quote-unquote punishment in medical contexts because it requires, quote, deliberate indifference to a serious medical need, end quote. Despite this early recognition, these cases still suffer under the weight of case law holding that incarcerated people are not entitled to specific treatment, including gender-affirming policies, medical treatment, or housing. Now, this poses a massive hindrance for trans people's ability to be transferred to a gender-aligned prison or even seeking gender-affirming medical care, since they are at the whims of the institution's doctors to decide whether treatment is suitable for what might argue their gender dysphoria. This represents the medicalization of trans people in American prisons that largely ignores any possibility of social transition, since appearance is tightly regulated. However, there is indication that tides may be changing on the ability for medical professionals to refuse surgery. So regarding the second notable finding on the use of segregation, at first glance, these numbers, it would seem that segregation, or in other words, solitary confinement, was less prevalent for American trans inmates compared to Canadian. Only 25% of American cases report segregation, as opposed to over the 80% in Canadian cases. However, it's important to take note of the types of cases before American courts. This American case sample predominantly deals with medical cases for denial of hormones, and therefore the pleadings are less likely to contain commentary on adverse prison conditions because they are not material to the case itself. There is, however, a marked difference in the acceptability of solitary confinement in American jurisprudence. So, what do these findings suggest for us? Well, to begin, there remains problematic issues for trans persons living in carceral systems. Considering the context, the complexities inherent in the Canadian correctional landscape come to the forefront, where the interplay between rights and risks for trans inmates is palpable. While CSC Bulletin 584 initially appeared to uphold or to hold promise by introducing individualized protocols for trans inmates based on their gender identity, its subsequent implementation has revealed a web of challenges that persist within this carceral environment. As we shift our focus to a deeper analysis, there are main issues arising, including but not limited to the challenges of trans inmate placement within and between prisons, enduring societal perceptions of trans people, the underlying socio-carceral dynamics that perpetuate a culture of violence and mistreatment, and the evolving character of correctional facilities as liminal spaces. So at the crux of our exploration lies the pivotal cases in the Canadian context of Kavanaugh and Boulichanis, as both landmark instances that bestow invaluable insights into the nexus of legal proceedings and the intricate fabric of trans prison culture. The Kavanaugh case, an embodiment of the struggle of trans inmates, has cast a revealing light on the tug-of-war between institutional decision-making and judicial oversight, underscoring the intricacies entwined with housing and treatment options for trans individuals. The subsequent Boulichanis case adds another layer of complexity, shedding light on the intricate considerations surrounding overriding health and safety concerns within that prison context. So beyond the legal dynamics, we also see number 4 happening in this light. These environments are marked by transience where inmates grapple not only with their sentences, but also with the challenges of navigating a system in constant flux. Our analysis illuminates these temporal facets of seeking justice within the context and the confines of correctional institutions by offering a glimpse into the profound struggles endured by trans individuals as they strive to assert their rights and carve a path towards equity amid the ever-shifting socio-carceral landscape. So now that we have this chapter under wraps, let's move on to the other findings that I worked on with my wonderful co-author and RA, Ava. So research here demonstrates that there are numerous unique needs and risks within corrections that place gender-diverse inmates at an increased risk of victimization and violence. And this chapter specifically, which we take from a more prison psychological perspective, discusses the barriers present for queer inmates in Canadian correctional institutions while comparing the literature to the OCI reports I referred to at the beginning of my talk, in which we examine overarching human rights issues for queer inmates. Now, although queer inmates present unique risks and needs within institutions, these inmates should have the same protection, treatment, and status as other individuals. Now, given the OCI's responsibility to hold federal corrections accountable, we felt the reports provide a unique opportunity to determine what ongoing challenges arise in these perennial reports and whether queer inmate concerns are recognized and addressed. And in doing so, we conducted a review of all the OCI reports, starting from 2009 to the most recent iteration, 2022. And through a thematic analysis of these reports, overarching human rights issues for offenders in institutions were explored. Right, so 1 second. Thank you. So what do we mean when we talk about correctional programming? Well, it's associated with greater likelihood of conditional release grants, lower readmission, and decreased recidivism rates. Yet, a significant portion of the inmate population have a history of unstable work and/or lack job skills. For example, dependability, reliability, ability to work with others, and so on. As such, CSC has incorporated programming for gender-diverse inmates that aims to decrease and manage criminogenic risk factors, while also increasing ties with the queer community outside of prison. All gender-diverse inmates admitted to Canadian institutions are to be informed of any programming available to them, and forms of programming can include, but are not limited to, internal programming such as education and support groups, and external to the correctional system such as pen pal support groups and initiatives. For example, the Prisoner Correspondence Project we've seen is a pen pal program. It operates within Canadian and American institutions. England has a similar program called the Bent Bars Program. And through these projects, queer offenders are paired with individuals from the queer community outside the institution. These initiatives aim to increase ties between the offender and the community, so upon release, offenders feel connected to the queer community. By strengthening gender-diverse inmates' ties with these communities and acknowledging and accepting their gender identity, these programs can assist with the offender's positive lifestyle changes while incarcerated. So our analysis that Ava and I undertook is broken down into two sections: structural barriers and interpersonal barriers. What do we mean by these two? Well, structural barriers are obstacles that can perpetuate the disparities of marginalized groups, such as gender-diverse offenders, and can include policies, practices, and other norms that favor non-marginalized groups. Interpersonal barriers are behavioral patterns that may impede how you communicate and how others communicate with you, such as the attitudes and interactions with correctional staff. Now, given the time that I have left, I will only be able to be discussing structural barriers, but I'm certainly happy to chat further about interpersonal barriers after the lecture. So in terms of structural barriers, we found several that queer people face in Canadian prisons, such as segregation, placement, and access to healthcare, right? These items most notably parallel what we've already discussed in the other chapter. However, what is important to note for the second set of research is assessment practices. Now, assessment practices for offenders include risk assessments to determine rates of recidivism, as well as assessments for program referrals. Currently, there's little empirical evidence that attests to the use of current assessment tools for gender-diverse individuals. There are numerous unique considerations for assessments within this population, and this can include but not limited to gender identity and how it's categorized, the effects of hormone therapy on assessments, and other unknown risk factors distinctive to this population. So to date, most risk assessment tools used for federal prison intake and correctional programming either have not changed significantly or at all to reflect gender identity. So we argue this is something that we need to be changing. So now that we've gone through both sets of research today, and I'm glad we've all stayed around for it, that's wonderful, where does our discussion take us? Well, in other words, so what? What's the point in everything that I've just talked about for the last time? I don't have a clock, so I'm assuming for a significant amount of time. Well, despite the serious concerns I've thus outlined here, I'm not a counsel of despair, and I still believe all hope is not lost. Now is the time to foster rehabilitative services and support systems for already marginalized and criminalized populations, especially in the context of the ongoing impacts of the COVID-19 pandemic. This call to action necessitates an understanding of how a variety of government and non-government organizations active in marginalized neighborhoods and marginalized communities see their role and have responded to COVID-19, right? We are still dealing with these effects of COVID. And so we have to be mindful of this, especially when we're understanding the queer community. Indeed, emerging research points to the central role of interagency collaboration and therapeutic alliances, a notion I take from parole and probation work, between government and community-based non-government organizations for these populations. From lockdown imprisonment to lockdown communities, the pains of continued isolation and exclusion, despite having regained some of their mobility and freedom, remains significant to understand. The goal of this is to call and to reconsider what these organizations may offer in terms of supporting already marginalized populations, the queer community included, in building a resilient post-pandemic infrastructure of services and supports, and having Canadian law, public policy, and correctional policy aligned to these services and supports. Yet, in the absence of robust interrogation and introspection, it is probable that confluent interests from the most regressive sectors of society, I may even suggest even those with extreme conservative ideologies regarding those incarcerated and those who identify with the queer community, will continue to extend the scope of supervision, penal or otherwise, in the lives and communities of already marginalized people. If that is the case, it becomes an evasion of the responsibilities of scholars, advocates, and activists to inform policy communities and the wider public of the foreseeable consequences of decisions taken at least nominally in our name. Not to do this is to leave those whom it empowers to make relatively invisible and unaccountable decisions. As Stanley Cohen, a notable criminologist, my background is criminology, so I certainly draw on him, made eloquently clear in another context, there are a variety of ways of knowing or avoiding knowledge, or I should say there are a variety of ways of not knowing or avoiding knowledge about the suffering of others. The challenge then is thinking harder about whether those in power are being held to adequate forms of public accountability, about the ways the public are or should be further empowered to engage in democratic decision-making, and how evidence-based research in law and justice can assist us in the process of public amelioration. Cough, cough, I think you have a provincial election on the 3rd, so go vote, it's important. I think so. The project of Rainbow Captives, as we are trying to work on here and go forward with, endeavors to address the first two challenges. And it is my hope that we can begin to bridge law and policy implementation to address the third. As a final note, we can clearly see how the costs of carceral expansion now extend well beyond the length of a prison term. In effect, my research continues to endorse more socially conscious and morally charged perceptions of penal affairs. Such penological thinking also incorporates and enriches more capacious conceptions of legitimacy. If we remain at all interested in the assertion that the very purpose of producing knowledge about the social world is to change it, and to progress pro-social change for already marginalized groups in society, queer communities included, then in this spirit, we must continue to question the legitimacy of penal arrangements as they currently stand, and where these arrangements are taking us going forward, and what direct and indirect harms the queer community will suffer if we do nothing to change our current trajectory. So in closing my lecture, I want to give my sincere thanks for you all for joining me today, and I look forward to our conversations today and beyond. Thank you so much.